Let's give people a little time. Oh, there's 4 of us. We could. Oh, there we go, Jane. Okay. It is 10:45 and let's go back on the record. And we just finished item number 3. So we'll go and move forward to number 4, stock cooperatives and uniform TOD Security Registration Act.
Yeah, thank
Brian.
you. That's memorandum 2115. I had hoped that I could present a complete tentative recommendation for approval at this meeting, but the legislative program has been consuming a lot of time and I just didn't get it done. So what I did present is the draft legislation. It's my best attempt to take all of the decisions that have been made in this study and translate it into statutory language for inclusion in a tentative recommendation. You know, I make a few notes in the memo about sort of broad issues I addressed in drafting, mostly about the location. There's a part in, a division, which is the highest level of organization in the probate code, for non-probate transfers. And so it clearly belongs in there. And because it's so closely tied to the RTOD deed statute, I wanted to have them be adjacent. And there's no room really with convenient numbering in front of the RTOD deed statute, so I thought it should follow. And when I looked at that location in the immediately following the RTOD deed statute, I found this law on gifts in view of impending death. And when I looked at that statute, it struck me that I don't think that's a non-probate transfer statute. That's a statute that has to do with people who give away personal property in anticipation of dying soon and what the consequences of such gifts are. So they're gifts made during life. They're not gifts that operate on death. So they really aren't, they're outside of probate, those gifts, but they aren't testamentary. And so I just don't think they belong in that division. So my proposal was to move that statute without change and put our new statute in its place. Another broad issue I addressed was whether or not to try to integrate this content into the existing RTOD deed statute or have it be its own standalone statute. When you look at the language, you see how many of the provisions are borrowed from the RTOD deed statute without significant change. They really are, it really is I'd say about a 80% clone. And so, you know, the possibility existed to take the existing statute and make necessary adjustments to it so that it would also apply to interests in a stock co-op. But that would have required some fiddly sort of terminology changes and the addition of a block of statutes that would be special exceptions for stock co-ops, and could have been done that way, but it struck me that it would be a little harder to understand and use. It would complicate both the existing RTOD deed statute and the new statute we're proposing. And so although it's technically kind of inefficient in terms of requiring more words in the code, I thought it was better to do this as its own standalone statute with a lot of duplicative language. One downside of that is that if the legislature decides in the future to change one of those statutes to improve it, and they don't realize that the same issue exists in the other one, they may miss the fact that there's parallelism and that they should make the change in 2 places. But on balance, I decided that, you know, the balance of benefits and costs favored having it as its own. Does anyone see that differently? Because I could prepare a different version, a blended version.
No.
I liked it separated because then if you're a layperson, you need to figure out where to look. So this is good.
Okay, so in the comments to the sections, when they're derivative of the RTOD deed statute, I've flagged that. So that will help people in the future to understand the relationship. And then the last issue, broad issue, was the relationship to our follow-up study that's of RTOD deeds that's currently pending in the legislature. The improvements that we're recommending for that statute, many of them would also be beneficial in this context, and the commission has already decided to include parallel provisions. And I have flagged those in the draft because I think that those are maybe more tentative decisions than the rest of the decisions in the tentative recommendation, because if we find this year that the legislature rejects some of our proposed improvements to the RTOD deed statute, then presumably we shouldn't include them in this statute, that the grounds for rejecting them as a matter of policy would be the same. I flagged those two that have that kind of connection to that pending bill, just to alert readers and remind us that some of this stuff is probably contingent on what happens to the pending bill SB 315. That's all the sort of overview themes that I talked about in the memo. The rest of it is nuts and bolts. And if anyone has any concerns about the nuts and bolts, we can address them at this time. You will see this language again, because at the next meeting, I will have had time to prepare the narrative explanation that we always include in a tentative recommendation. And so you'll see a complete tentative recommendation, which will include that narrative and this draft legislation. So you'll have another bite at the apple if you want to think longer about the merits of the language. But if anything jumped out at you at this stage that you saw as that concerned you about the draft legislation, we could fix it now. No?
You don't have any comments?
So that's it for that memo, because I don't think we need to, like I said, I'm going to be bringing this back, so we don't need to approve it formally. It'll be approved as part of the tentative recommendation as a whole. So I'm done with that item.
Very good, thank you. We'll go to item number 5. Ms. Barbara is going to talk to us about the statute made obsolete.
Qualification statutes. So this memo focuses on whether the judicial disqualification statutes in the Code of Civil Procedure should be revised to provide additional guidance on a problem that arose from trial court unification. How to handle the situation where a Superior Court judge rules on some aspect of what used to be a municipal court case and now is known as a limited civil case. And then the same judge also has a possibility of serving on a panel of the appellate division of the Superior Court that considers an appeal from a judgment in that case. And so the issue is really whether the judge is disqualified from participating in the appeal. As explained in the case of Housing Authority of Monterey County versus Jones, a judge is disqualified from serving on an appellate division panel if the judge heard and ruled on the same quote unquote proceeding as the one on appeal. And that's Code of Civil Procedure section 170.1B. For example, if the judge heard, was the one where who tried an unlawful detainer case and entered judgment in the unlawful detainer case, then that judge could not participate in the appellate division panel that heard an appeal from the judgment in the unlawful detainer case. Now, in the Jones case, the Court of Appeal also decided that a judge is disqualified if the judge heard a pretrial matter involving a contested factual or legal issue related to the merits, or made a procedural determination that had a substantial effect on the ultimate outcome in a case, or where the determination that the judge made, though not directly appealable, is related to an issue on appeal from the final judgment. The Jones Court of Appeal based that decision on the part of Code of Civil Procedure section 170.1 that says that a judge is disqualified, quote, when a person aware of the facts might reasonably entertain a doubt that the judge would be able to be impartial, close quote. So the Jones Court reached that decision that there are two different prongs for disqualifying a judge from serving on an appellate division panel, and that statutory law already supports the existence of those two different prongs. But the Court of Appeal in Jones suggested that the legislature should revise the judicial disqualification statutes to address this situation more precisely and clearly. And that's the question for the commission to decide today, whether such statutory guidance is needed. The memo that you have before you has some staff analysis of both the potential advantages and the potential disadvantages of proposing legislation. In terms of potential advantages, I mean, this is something that is within the commission's bailiwick. The commission has been responsible for not evaluating the wisdom of trial court unification, but for helping to make pre-unification procedures properly work in a unified court system. So this is something within the commission's bailiwick. It might be a relatively simple matter to follow up on the suggestions of the Court of Appeal in terms of providing further guidance. On page 9 of the memo is a possible way to incorporate into the existing statute the language, some of the language from the court's opinion. That wouldn't substantively change the law. It would make the guidance of Jones more readily accessible to people who are working with situations where there might be a disqualification issue. And so it might help reduce some uncertainty, cut down some litigation costs, and prevent some wasted efforts. In terms of potential disadvantages of proposing legislation, frankly, it's not clear that any additional guidance is needed at this point. The Jones case was decided in 2005. To my knowledge, there haven't been any further certainly published opinions on it, on this kind of issue. I'm not aware of any, set of disputes where this kind of problem has come up. So this may be basically a solution in search of a problem. Even if there is an ongoing problem, it may not be the best solution to address it by statute. It might be more advisable to address it by leaving it to the courts to address on a case-by-case basis in the context of concrete factual situations. And I guess one further consideration in terms of trying to address this is that, as explained in the memo, the Commission and the Judicial Council both engaged in extensive efforts to address what could be seen as this peer review problem created by unifying the trial courts. The concept of having a Superior Court judge having his or her ruling reviewed by other members of the same court sitting on the appellate division. And although there were much discussion, lots of effort put into trying to come up with a more satisfactory approach to that peer review problem than is currently exists. And you know, there were many steps taken to minimize the peer review problem as best as possible. The finding an optimal solution, you know, one that put everything to rest in terms of concerns about peer review, just really proved elusive for the commission and the Judicial Council and the legislature. And so this would perhaps be reopening a can of worms. And so those are my thoughts on the pros and cons of dealing with this situation. And I think at this point, we should just open it up for discussion among the commissioners and any members of the public. I don't think anybody's here on this matter. I may be wrong about that, but.
We have Jeff Brooks and Wendy Bogdan. Do you recognize those names, Barbara?
I don't.
Okay. Commissioner Simpson?
Yeah, actually, I have a little bit of experience on this issue as recently as yesterday. In my other hat on the Commission on Judicial Performance, disqualification and disclosure issues are typically in the top 2 or 3 types of behavior or circumstances, whereas behavior where we impose discipline on judges, as I say, we did it as recently as yesterday. Among my colleagues on the CJP, there are 2 Superior Court judges and 1 appellate justice, Bill Dado from the San Diego district, who actually, before he was elevated to the Court of Appeals, served on the appellate division in San Diego County Superior Court. And so I asked the 3 of them, as well as Greg Dresser, our executive director, about this issue, and did they think that this was something that needed statutory change? None of them thought it was. It was to a large extent, probably, I think, as Barbara mentioned, likely be a solution in search of a problem. Did not think it was something that rose to the level of needed to be changed in statute. So I simply want to share that with the group to set some context.
And in addition to having to do my 2 hours of ethics training for this commission, I had to do 3 hours of training for my judicial stuff. And they spend like a whole segment, Barbara, on disqualification. And you are constantly told you never want to be a person who has to deal with these panels, or, you know, but to make decisions, but, you know, don't fear this, but at the same time, you know, make sure that you're there, that you raise conflicts when you know that you have either ruled on something, like you said, especially in unlawful detainer actions, if you ruled on a motion and then you have to deal with the trial later. But I think there's a lot of training. I think that people are aware of it. I do think, you know, depending on, especially like with right now with LA Superior Court, where there are people that are out, staff is limited because of COVID or whatever is going on, and each courthouse has their own rules going on. We probably don't need to create an actual statutory frame on how to disqualify. I think we would defer to the presiding judges for different courts, and it's probably fine. Any comments from anyone else?
I just want to say thank you to Commissioner Simpson for seeking that input. I think it's really helpful to have that real world perspective, and also for the chair for her real world perspective on this.
Yeah, I'm just trying to figure out if I have jurisdiction over the chair and her, you know, temporary.
You're the vice chair. No. And
No,
no,
like, you know, when you're
no,
temporary
you will
judge.
never. I just do unlawful detainers and traffic stuff and small claims. Hopefully you never see me.
We do court commissioners, we do small claims, we do all kinds. So you just, you know.
All right. Okay, well then we'll go then, Barbara.
Do we have a motion then to basically not to pursue this matter further?
So moved.
And I'll second it. Good. And all those in favor, say aye. Aye. Yeah.
Okay. Thank you.
Let's see. We're moving along to the last items. Mr. Steve, you're on for Fish and Game Law.
Okay, thank you. Hello again, everyone. So first, a brief refresher on where we are in the study through the last commission meeting. Very quickly, the commission has previously approved and circulated for public comment a tentative recommendation some time ago proposing a recodified Fish and Wildlife Code. And that recommendation proposed or inquired about a number of textual changes to existing code sections and also proposed to reorganize and recodify those provisions. Following the release of the tentative recommendation, the commission worked closely with the two state entities that have the most expertise relating to the provisions of the Fish and Game Code to obtain their comment on the changes. Both entities spent a tremendous amount of time reviewing the recommendation and in the course of doing so proposed to the commission that it consider their comments in two phases. Phase one would include consideration of comments relating only to the proposed textual changes to existing provisions. And phase two would involve consideration of comments relating to the reorganization and recodification of the code. The commission agreed to that proposal. And having now received the entity's phase one comments, at the last commission meeting, the commission decided it would begin preparation of a recommendation that would be based only on those phase one comments, which would then make only non-organizational revision of provisions of the existing Fish and Game Code. So that's where we are now. The question about reorganization and recodification would be taken up at a later time. So this memorandum primarily presents for the commission's approval a methodology by which the commission might efficiently consider all the proposed changes to existing sections, proposed textual changes, while incorporating the many phase one comments, about 850 or so comments that were received from the two entities relating to those changes. The memo explains the proposed methodology and offers a few examples as to how it might work. Of course, the commission at any time could direct the staff to tweak or even significantly change the methodology, but if it found it acceptable, then what we would start doing in subsequent meetings is presenting the commission with much larger batches of these proposed textual changes using that proposed methodology. The methodology is set out beginning on page 2 of the memorandum. What the staff has proposed is that in each memo going forward, the staff would present the proposed textual changes after first placing them in one of 5 categories that are described in the memo. Each category would be substantially based on the nature and or the existence of the comments from the entities about the changes. And those comments would also be reproduced in an exhibit that would look like what you have as the exhibit attached to this memo. And then when we presented the memo, the changes in each category would be initially addressed in the aggregate by the staff, as indicated again in the memo. And I'll go through now the categories and the procedures for each category. So category 1, entitled Changes That Should Be Made, would include proposed changes that one or both of the entities agreed should be made and neither have opposed. We would offer those changes to the commission as presumed consent items for approval. In other words, in the aggregate, they would be presented to the commission for a decision. There would be a brief description of each item in the memo, as there is in this memo. And then I would ask if anyone has any question about any of the items, or if anyone has an objection to any of the items being in that category. And if not, the items would then be presumed or deemed approved for inclusion as a proposed change in the recommendation that the commission is preparing. The staff would not discuss any item individually beyond what was presented in the memorandum. Of course, if someone did raise an issue or had a question, the staff would be prepared to address that, but otherwise we would then just move on to the next category. Category 2, entitled changes that should not be made, would be changes that the staff is recommending not be included in a new recommendation because either one or both of the entities have objected to the change and neither have supported it. Again, the same procedure. They would be listed in the memo, and the staff would ask if anyone had any questions about any of the items or an objection to the item being included in the category. But if not, these items would all be deemed disapproved and not be included in the recommendation. Third category is entitled changes that should presumptively be made. These are proposed changes that we did not receive any comment on from either entity. And so what we propose to do here, rather than have the commission take any action on that, since we hadn't heard from the entity, would be that we would essentially bump these changes up to the first category in the next memorandum that would be presented to the commission. And that would give the entities notice as to these specific changes and ask for any comments that they would have to make sure that they didn't have any objection to the proposed change the commission had previously recommended. And so then those changes would appear in category 1 the following meeting. But again, would be treated the same way. No discussion on the item unless a commissioner had a question or objection to the item being in the category. Category 4, entitled further input required, are for changes that the staff felt it would be helpful to have some further input from one or both of the entities before presenting the change to the commission. Possible reasons for this would be that the staff did not understand a comment that had been submitted by an entity, or that perhaps the entity in submitting a comment did not, may not have understood what the commission's goal was in proposing the change or in inquiring about the change. In some of these cases, the tentative recommendation had notes following a proposed change or following a section which is not changed, but the commission was considering a change. And the note might have asked a question like, would it be a good idea to make this change, for example, or we're wondering why we shouldn't change this because this reason or that reason. And those are often, that's often the situation where we might get a response back and there might not have been, there might have been a little bit of a disconnect between the question asked and the answer that came back. Or the entities themselves might disagree. One might approve or support the change and the other might not. So the proposal there would be that the staff would, again, ask if any commissioner had a question or wanted to do anything different in terms of the categorization of the change, but otherwise the staff would seek further input from the entities. And once we got that input, we would come back with the change and a further report on, and it would likely be put in another category at that point. And then the last category, labeled purely informational matters, these are items where the commission didn't propose any change, but included a note after a section, either just generally offering some information. This was an urgency bill, and so we've used this text, whatever. Or it might have asked a question and an entity responded in a way that made it clear we didn't need to do anything to the section. So those would just be listed as they are in the memo. And there would be no further action that would be needed by the commission, again, unless a commissioner had a question or an objection to the item being in that category. So with regard to all these categories, the staff would be applying the two limiting principles that applied in this study. First, the legislature has directed us that we not make any significant substantive change to existing law. So that's a governing principle. And the second is a commission decision, which was that we would only include a change in the proposed law if it met each of the following 3 criteria. That the change had to be plainly beneficial, not present a significant risk of unintended consequences, and not likely be controversial. So the staff would be applying all those principles to any change before presenting it to the commission. And then you'll see that they're listed as in the memo, the proposed changes will be listed in numerical order according to how they appear in the tentative recommendation. That's both largely because that's the order in which the comments were submitted to us, but also it would be, hopefully it's helpful to you if you want to see the change in context. You can start at the beginning of the tentative recommendation if you want to have that open when you're reviewing the memo, and you'll be able to just skim to the next one, and you won't have to be jumping all over the place or looking at a code that's not annotated. Okay, so I think I've explained the methodology. Questions about the methodology first?
You know what, before I see, Wendy, I see, and then I'm not sure about you, Mr. Brooks, were you guys here on this study? Did you want to add, or did you have any comments to make? There's one
I will,
hand up.
Ms. Bogdan has her hand up. I'll enable her to speak.
Okay, thanks.
You have to unmute yourself. There you go.
Thank you. Can you hear me?
We can.
Yes.
Oh, great. Thank you. I just wanted to take a moment to acknowledge the work of the commission. Really appreciate this. We did receive this proposal on Monday. We haven't had a chance to go through it, really reflect and see how it aligns with our staffing interests and capacity. But we really look forward to working with you all on this. And as we said, when we spoke with you at the last meeting, we really do believe that there are some important and very significant improvements that can be made through this effort. So thank you for that.
Thank you. Okay, any commissioners have any additional comments?
I was going to say, I think Steve's approach sounds very thorough, reasonable, and I think it makes sense.
I liked it too, Steve. It's a good approach to dealing with, just hearing and filtering through different comments and opinions. This is good.
Okay, well, so can I take that as an indication that the commission, at least at this point, is accepting of the proposed methodology? Okay.
Yep. Everyone's nodding their head. Yes.
All right, great, thanks. I just want to make sure that I know who's here. Okay. All right, I'll get it later. Okay, thank you. Okay, so let's give it a try here with some examples that we used here. These would be the first changes that we would use. I don't mean when I call them examples, they're illustrations of how the methodology will work, but these would be the first sets of changes that the commission would be looking at. So if you turn to page 4 of the memo, we have 4 proposed changes that are in the category 1, changes that should be made. And the way we would do this is I would hope everyone certainly would have looked at the memo, and then I will ask, does anybody have any questions about any of the 4 proposed changes which are in this category, or any objection to any of the proposed changes being in this category?
So then I would say, what's the difference between a coot and a gallinule?
Okay, so I'm guessing we are on the second item, which is proposed section 490, which lists.
And that's hazing. If you're not an official commissioner unless you ask about these, because all of us have done it at once.
I'll
Ms.
withdraw my
Bogdan,
question.
Wendy, I would be happy to defer to Wendy and the expertise that comes.
Oh, we have another hand up. Wendy, did you want to help out, and then I see Angela too.
Well, I mean, I think this is such a great example of why it's really necessary to bring to bear so many different areas of expertise within the department to any particular change. Obviously, I didn't go to law school to learn the difference between a coot and a something. And it's part of why this effort is just so incredibly labor intensive for us. So I just want to reiterate, I've not had a chance to really review and reflect the proposed methodology and the extent to which it aligns with our staffing capacity. And I just want to make sure that I understand what you all are kind of stepping through right now. Just some examples to illustrate for yourselves how you anticipate this process unfolding in the future. Is that correct?
Yes.
That's, yes, that's the proposal, yes.
Okay. Yeah, like I said, I'm not in a position at this meeting, having just received this on Monday, to be able to weigh in support of it or not. And I certainly am not in a position to advise as to different the different species that might be implicated by any particular section.
Good answer. Good answer.
I don't,
Okay, I didn't go to law school, and I don't know the answer either, so.
that would not be, I was assuming that was, well, I don't know how to characterize it, but that was not involved in any proposed change.
Yeah, I saw that.
The two species that were asked about, that just happens to be in the list, and that
Well,
would
the bad news, Rick, is that according to the dictionary, a coot is a foolish or eccentric person, typically an old man.
Oops,
Hey, I resent
Other
that.
definition though.
I resembled that. Yeah, okay.
All right.
You also have another hand up from
And Donlan.
Ms. Donlan. I'll activate her. And Angela, you need to unmute yourself.
Hi, thank you. I'm also an attorney with the department. And Steve, I appreciate all of the background and the proposed process. You know, I think, as Wendy said, I just want to echo the fact that we have so many really specialized issues that come up in each of the code sections that you guys are going to be grappling with. Is one of the reasons why it's really hard for us to bring everyone to any one meeting that could answer questions you guys might have. And it kind of, I think, is revealing about why in the past we moved to kind of participating in writing, because then we could have all the specialties necessary present and reflected in our response. I think that having items on the consent calendar that we all agree with works really well until one of the commissioners may want to pull one of those items off the consent calendar. And I just want to make sure that those items would then go into the category of something that we could interact with you on informally between meetings, and we wouldn't have to have necessarily the appropriate staff present at that meeting to answer those questions if something got pulled off the consent calendar, or someone wanted to discuss something on the consent calendar. We're not going to be staffed up in the moment all the time to be able to address those things at that meeting.
That seems sensible to me.
Mhm. That was definitely what I was expecting. Anything that came off would be then reclassified for the next meeting, probably.
Okay.
So there would be opportunity to.
And it's a reasonable question, because that's different from how legislative committees operate. If they pull something off the consent calendar, they're still going to vote on it at that hearing. And I think that Ms. Donlan makes a good point, that it would make sense instead, if we'd be pulling it off because we think more information is needed, that we then kick it over to a subsequent meeting where we could give you a presentation in writing of the background information before you decide.
Thank you.
I might suggest the only qualification of that might be that depends on the reason for which it was taken off the consent calendar. It may be that somebody wanted to vote no just on that one item and everybody else wanted to vote aye. So that, I mean, keep as a potential process.
So if you're saying if it's taken off consent, but the presumed result winds up being the actual result, then there's no reason to revisit it at a future meeting.
Yeah.
Yeah, that makes sense.
That's right.
We'll apply a rule of reason.
There we go.
It's good.
All right. So this first category, changes that should be made. We had 4 proposed changes in there. Any other questions about any of the proposed changes or any objections to any of the 4 items being included as presumed consent, which would mean that these changes would be included in the recommendation. At least they're deemed to be at this point approved for inclusion in the recommendation. Okay, I can't see.
And commissioners should feel free to jump in and say, move the consent items if you.
Move the consent item.
Or something. Yeah, it's hard to see. It's hard to see everybody at the same time. So I don't know if somebody is raising a hand or something. So.
No, I would help you, but no one has any concerns. So.
Okay, excellent. Okay, so now moving on to the second category, which is changes that should not be made. We have 3 proposed changes listed. Again, these would deem to be not approved and not included in the recommendation. Does anybody have any questions about any of these changes or any objection to any of these changes being in this category?
I'm actually looking to Commissioner Carrillo because he usually says, just move to, just like Brian just said.
I move the item.
Okay, we may as well, we'll have to see when next meeting, when we have many more in each section. I guess it'll probably be look a little bit different, but
or alternatively, another thing we could do is if all of the categories are being treated on a consent basis, we could just say at the outset of the memo, does any commissioner have anything they want to discuss in this memo? Otherwise, we'll presume approval.
I like that. We're all okay. So we got you two.
I mean, that puts the burden on commissioners to like speak up if you've spotted something that you think warrants further discussion.
I think it's good. Commissioner Rubin, did you have something to say?
I have categorically no objections whatsoever to the conversation that we've just had. And
Okay.
I completely support Commissioner Carrillo's, I believe you made the motion to move forward the consent. Without further ado, we should.
Okay.
okay.
I think it's
so-
a good idea because we're short for time on these meetings. We're just doing our mornings. So I think it's a little more effective. So I
think-
second that.
All right, third category is changes that should presumptively be made. This gives you an illustration of the types of changes that will be in each category. So perhaps that's some help here. This was a relatively minor change that was not commented on by either entity. And probably for understandable reasons because it wasn't called out specifically in the tentative recommendation. So the proposal would be that this will be presented at the next meeting where we present these changes as a category 1 change, which should be made. But in the meantime, there'll be an opportunity for the entities to have a whole meeting cycle to register any objection or any other comment they have. Any question about this item? This is that we're now at the where are we? Top of page 8. This item, any question about it or an objection to it being treated that way?
Everyone's
Seeing none. Moving on to the next category, further input required. We have 2 items in this category. And again, how we propose to treat these items is to talk to the entities. We're not sure about how to best present these, and we'd like to have some further conversation with the entities or their staff, and then would come back to the commission with further information. Questions about either of these items or objection to the items being in this category?
Nope.
Okay, seeing none, the last category is purely informational matters. Again, these are items that were actually not even proposed changes. We asked questions in the tentative recommendation. Either they were, and they've been addressed such that we don't need a change, or the note didn't even ask a question. It was just an explanatory note. And so these are just listed here for completeness because there is a comment on the section in the exhibit. Questions about these items, any of these items, or objection to these items being in this category? Nope. Okay, I think that we're good then, unless anybody has any questions overall about how we're going to proceed at this point. Okay, thank you.
I see that this may be a holdover, but Ms. Bogdan has showing her hand raised. Did you want to say something in conclusion? No?
Yes. I just want to make sure I'm clear on the expectations, on your expectations between now and the next meeting for what's going to unfold with respect to this work product.
So I think the remaining items, the holdover items, are some of the presumptive approval items. And so you should look at those, have your appropriate staff look at them. That's where we got no comment and we presume that it's okay. We're taking your silence as assent. So if we will present those again at the next meeting, if you don't want your silence to be taken as assent, speak up. Or if you need more time for that than a single meeting cycle, tell us. That's
Yes.
fine.
I think, to be clear, I've not had a chance to review the memo that was issued on Monday. So I'm listening to this and hearing this consideration, but I'm not endorsing it.
Sure.
And I haven't had a chance to be able to look at this, see whether or not I agree with the recommendations.
I mean,
Again, and assess what the work requirement is going to be for us for the before now and the next meeting.
If it helps, I think the methodology breaks into two big pieces. And the first piece is we're doing what you suggested. And I assume that that's not going to require, assuming that the commission concurs, that that's not going to require any more work. The other half is we'd like to talk a little bit more before asking the commission to make a final decision. And those are listed, and Steve will reach out, and the decision will not be made at the meeting at which you first see those items. You'll have at least another month. So the easy low-hanging fruit we'll pick. The rest of the stuff will kick it down the road at least a month.
Right, and so there's two categories that Brian's just described. One is the presumed consent items, like in this case, we have one item on page 8, and it's a change that no one has commented on, but it's probably pretty minor, and that you'll definitely have a month. The items that are listed as further input required, certainly within reason, you'll have as much time as you need. In other words, I'll be in touch with staff, with your staff, and whatever time is needed. If it's like, well, we have to look into this, we're not really sure, it's going to take a while, then that's how long we'll take before we report back to the commission.
Yeah, that's a good point. And then Wendy, that should give you time to circulate and ask for opinion and feel comfortable with having us go forward. We're not that inflexible where it's like, no, too late, it doesn't work that way.
And if you need more time than a single meeting cycle, just say, and we'll.
Okay. I appreciate this, and part of what I'm trying to do here is just really set us all up for success in terms of dialogue and iterating on all of this. So please don't take my words as being I don't know, presuming that these changes aren't good. That's not my presumption. My presumption was that our review identified some changes that could be really helpful. But we all know how much a miscategorization of something can be then difficult to unwind down the line, and moving a comma. And you all know that better than anybody else, the consequences of that. So I just really want to make sure that we honor your work and set this up for success by setting expectations. And our staff, like yours, has been tremendously impacted over the last year. And so I need to be very, very realistic about what I can what I can task them with. So thank you for hearing that. And I look forward to following up with Brian and separately to just make sure that we're really, on the same page, sort of shoulder to shoulder collaborating on this. Thank you.
Well,
No,
and
we're so happy to have you here.
the other thing I would add is that the methodology that Steve's memo proposes and that the commission just blessed can always change. If we find that it's not working for some reason, we will revisit it. We agree with you. We're trying to find the best method for efficiently handling a large volume of information. And so we're not wedded to anything.
Thank you so much.
Ms. Donlan, did you want to speak?
Yeah, quickly, thank you. I just wanted to say that I think the process for items that we all agree on being on the consent calendar works, but and Steve, I know that you have incredible attention to detail, but I know I also will want to go through the process of just making sure that when I see the memo, I agree that all of the items that are on that list are things that we said in our comments. We agree with your change. And just with the workload that we have, and I'm sure that you guys have, getting a memo on Monday doesn't necessarily allow us to do that by Thursday.
Yeah.
And so I would say it works if we can get, at least a couple weeks to have that, go through that process to make sure we agree with the categorization.
Yeah, I agree with that. And I apologize for the lateness of the memo. We were kind of crunched during this cycle, and our goal going forward will be 2 weeks before a meeting date. That's our nominal release date.
Okay, thank you. That's great.
Yeah, and we used to meet, like every quarter. And so this is or every other month. So we've the whole schedule and how we work now has been changed since, due to COVID. But, just like Brian said, we're not wedded to any particular position. If it needs to be changed or revisited, then just feel free to use the process. You don't have to feel that, rushed either to be prepared for each meeting. Your attendance and participation, it helps us tremendously.
Thank you.
All right, you guys, with that, I think we're done with all the items. Are there any other questions or issues? Thank you, everyone. Thank you so much. Brian, you have a comment? Go ahead.
Yeah, I think Steve's item is done for the benefit of Ms. Donlan and Bogdan. But I would like to ask a general process question. I am in the intervals between now and the next meeting, I will be having more bill hearings. And I just wanted to check, and often the committee's expectations about how people are participating don't really square with us. One of the things we're always bumping into is that the committees want to know who's the sponsor of the bill. And I always try to say, well, we're not really the sponsor because that implies a degree of advocacy. It's based on our recommendation. and I think often people look at me and think, what are you talking about? Why are you drawing this very fine distinction? But we do draw that distinction when we're dealing with written materials like committee worksheets where it says sponsor. We'll tell the author staff, we're not the sponsor, just say it's based on our recommendation. When committees are having hearings, especially this year when they're doing it with conference calls, their expectation is that there's going to be support witnesses and opposition witnesses. And those are sort of organizational categories for them, how they structure their hearings. They'll say support witnesses, there'll be 2 support witnesses for a total of 4 minutes, 2 opposition witnesses for a total of 4 minutes. If they say something like that, I have never orally drawn the kind of distinction that I just explained. I've never said, well, Mr. Chair, just to be clear, we aren't a support witness, we're here just to explain. I usually will say in my testimony that I'm here to explain, and I don't offer any kind of advocacy. But or the author will say it. because the authors are also used to dealing with support and opposition, and the author might introduce me as a support witness. And
And I'm going to just intervene only, and I say this because I just think it's important for the record, just to be clear. We've moved on past that item. I don't think you owe any further justification, or I just think you're done. And
I appreciate that, but I just want to know what to do at the next hearing. If I get introduced as support, do you want me to correct the chair?
I think you should use your best discretion.
Okay.
I think that if it was rude to correct someone in their introduction to you, or you can use your discretion to then clarify, or to decide that there's no clarification needed because what you are going to state for the record is going to make it clear why you were there. The position, our edict, our everything that we have explains this commission. And every meeting we begin, it's on the website. I just don't think we need to revisit this. And I will apologize if I seemed abrupt, but I am acting on behalf of the commission. I put it as a motion before the commission. We all decided that it should be an item that we move forward on. So I just don't, I feel protective of the staff in the sense that I don't think anyone has to justify their position when you are acting in the good faith and with the best, wishes and and the best, I guess, efforts of the commission. I think we're done. Rick?
I concur with both you and with Brian. Just maybe some clarification. There's no definition of sponsor. That's sort of in the eye of the beholder.
Yeah.
I think it would be justifiable for them to say, if the sponsor, if they think of the sponsor as whoever it is that brought them this suggestion, well, that was us, right? It doesn't imply one way or the other, whether they're like, contributing money or whatever. So yeah. I honestly wouldn't be too concerned about that. But if in the context of where you are, you want to clarify that, that's fine too. But there is no definition of sponsor. People use it as a pejorative. People use it as to get support. It's,
Yeah. And you are the director. You have your own authority and bailiwick to make your decisions based on what is happening at the time. And for us to second guess what happened, that's not our position, and we wouldn't do that. You're qualified, you're able to do what you need to do to move our best interests forward, and we trust you on that. So there's no explanation needed.
Okay.
Okay.
I don't have anything else for the meeting.
Sending everyone a hug.
Move to adjourn.
I'm ending the recording. Bye, everyone.
Bye.